Well, North Yorkshire Police told us they only make applications to the court for sexual risk orders in circumstances where it is considered necessary to do so to protect the public from the risk of sexual harm. Sexual risk orders were first introduced in 2014 under the Antisocial Behaviour, Crime and Policing Act. Let's talk to Northumbria Police Commissioner Vera Baird. Good morning to you.
Good morning.
This man has done nothing wrong. He's not a criminal. He has no criminal convictions. He was cleared of rape. How is it fair that he's subject to one of these?
I think it's a completely different jurisdiction to anything to do with criminality and a conviction. He's not been convicted, he's not gone to prison. It's a different thing. The judge said that he was a very dangerous man. He clearly has a different point of view. Possibly we should park his case because there are two sides to everyone and consider the position. It's only if it's necessary to make an order to protect some member of the public or the public generally from sexual harm when somebody's already done something of a sexual nature that such an order can be made. That has to be proven on evidence to a court and it's preemptive. Classically, it's likely to be where somebody perhaps, a typical way of sexually abusing young women is if youngsters are hanging around on the street outside a coffee shop or a takeaway or a bar, they can be befriended. Then they might be taken to parties where there are older men and loads of drink. If something stops what looks like the inevitable conclusion and intention, sex to follow with underage girls, if something stops it, the girls get taken away, they're put into care, the police raid or whatever. Nonetheless, the court might well think it's necessary not to just wait till the next set of girls are not so lucky, but to make a preemptive order stopping men there from doing that stuff again. That's the intention. It is to protect against serious sexual harm. Against sexual harm.
Yeah, I understand, and it's interesting that we had to park the John O'Neill case, and you used that example. There is a role for them. Briefly, there is a role for them in this country when it comes to trying to stop potential crimes.
There's undoubtedly a preemptive role for them. It has got to be done on evidence, and it is just that it's a new provision, but it's one in a long line of orders of this kind that can stop people who there is in the court's mind a necessity to stop from taking steps. The police don't have to stand by and wait until the crime's committed. If they can prove to the court it's necessary to protect somebody, to stop those steps from being taken. His particular circumstances, clearly we don't have a full picture. There will have been a contested hearing in court. One, the judge said he was very dangerous. Two, he says it was just sour grapes from the police. He can appeal against it if that is the situation.
Okay.
But if you park that and consider the situation, obviously it is helpful for the police to be able to manage such people and helpful for us not to have vulnerable people put at risk because no crime has actually been committed, even though somebody may have been 2/3 of the way toward it.
Thank you very much, Vera Baird.